Hi, everyone. This is Jennifer McKay with Tip of the Mitt Watershed Council. We will get started here in just another minute, so hang tight. Okay, it's 1 after 2, so we will get started today. Welcome and thank you for joining today's webinar entitled Pipeline Permitting in Michigan, How to Effectively Participate in the Decision-Making Process. My name is Jennifer McKay. I am the Policy Director at Tip of the Mitt Watershed Council and your host for today's webinar. Community engagement is a vital part of many pipeline projects. Public participation contributes to better decisions because decision makers have more complete information in the form of additional facts, values, and perspectives obtained through public input. Decision makers can then incorporate the best information and expertise of all stakeholders. Ultimately, earlier and more productive involvement will lead to better project designs and can minimize the risks that pipelines pose. State and local regulations provide many opportunities for the public to participate in the regulatory processes for pipeline projects, but navigating through those various processes can often be overwhelming. So today's webinar is designed to help navigate that process by providing basic information about permitting for pipeline projects in Michigan and how you can effectively participate in the public process. The focus of today's webinar is state permitting in Michigan. We will soon have resources, including a dedicated webpage and a publication available that will provide information not only on what is being covered in today's webinar, but touches on other public engagement opportunities as well. So stay tuned for the release of those tools later this month. Today's webinar, as well as the resources coming soon, are all funded by the Pipeline and Hazardous Materials Safety Administration Technical Assistance Grant Program. Today you'll hear from two speakers. First, we have David Chisla. David is the manager of the Gas Operations Section for the Michigan Public Service Commission. David graduated from Michigan Technological University in 1993 with a bachelor's degree in civil engineering. He began working for the Michigan Public Service Commission in 1994 as an engineer, auditing natural gas utilities and pipeline companies for compliance with the Michigan gas safety standards. David was appointed to the manager of Gas Operations Section at the Commission in 2011. The Gas Operations Section has responsibility for enforcement of the Michigan gas safety standards, underground utility damage prevention, pipeline siting cases, natural gas production, gas distribution franchises, technical standards for gas service, natural gas storage, and related issues in natural gas utility cases. Next, you'll hear from Joseph Haas. Joe is a fifth-year district supervisor at the State of Michigan Environment, Great Lakes, and Energy, Gaylord District Office, Water Resources Division. He received a bachelor's degree in resource ecology and biology from the University of Michigan. His employment experiences include 8 years of regulatory programs in Saginaw Bay and Lansing, U.S. Fish and Wildlife Service trustee coordinator for the Tittabawassee River Natural Resources Damage Assessment and Restoration, Deepwater Horizon BP oil spill response, oiled wildlife collection for natural resources damage assessment and restoration on Chandler Islands, Fort Jackson, Louisiana, and Fairhope, Alabama, and oiled wildlife collection at Enbridge Pipeline 6B break in Marshall, Michigan. I invite you to submit questions during both of the presentations. You can do this in the question pane on the control panel. We've left a short time at the end of the hour for a Q&A session. My colleagues and I here at the Watershed Council will be reviewing and organizing the questions submitted, and we'll get through as many as time allows. Lastly, just so everyone knows, today's webinar is being recorded and will be posted to the Watershed Council's website, www.watershedcouncil.org. So at this point in time, I'm going to hand it off to Dave Chisla.
Thanks, Jennifer.
Dave, you have yourself muted.
There. I think you had me.
Better. Okay, try again.
Start from the top?
Yes, please.
Okay. In Michigan, there's 2 laws that specifically deal with pipeline siting cases. There's Act 9, which is for natural gas pipelines, and there's Act 16, which is for liquid pipelines. I'll talk about the processes that we go through when we receive an application. There's 2 primary processes that we go through. One would be for ex parte cases, and that would be a situation where just the staff and the pipeline company is involved. I'll talk about intervention in a pipeline case, and that would be the public, other pipeline companies or interested parties that can intervene in those cases. Contested cases, that would be a case that goes in front of an administrative law judge and then ultimately to the commission. I'll also talk about what staff does in reviewing a pipeline application. I'll also talk about public participation in this process and what it means to have effective public participation in the process. So Act 9 specifically gives the commission citing authority, and that citing authority is only for intrastate natural gas pipelines, so pipelines that are within the state. The reason it is only for intrastate pipelines is because the Federal Energy Regulatory Commission has authority over the interstate pipelines, so the pipelines that cross into other states or into Canada. The commission would grant eminent domain to the pipeline company if it deems that that is necessary, and then the pipeline company can use that eminent domain to take a landowner to court, and a local court, and specifically get condemnation rights to acquire the use of that property. And again, this is limited to intrastate pipelines for natural gas. The Act 9 also deals with the sale and purchase of that natural gas. So the pipeline companies are required to file contracts that they have in place for shipping natural gas on those pipelines with the commission. And then if there was an issue between the two companies where they couldn't come to an agreement in one of those contracts, they could file an application here at the commission for the commission to intervene and make a ruling in those issues that they're dealing with in those contracts. Act 9 also has provisions in it and gives the commission broad authority to prevent waste of natural gas. And then if there are issues with a pipeline company not following the law or a commission order, it gives the commission authority to issue civil penalties. Act 16 is structured very similar to Act 9. It grants the commission that same citing authority for a pipeline company. And in this situation, for a liquid pipeline company, it involves both intrastate and interstate crude oil production or petroleum product in the pipeline. So it can be either a pipeline that's solely within the state or one that crosses into other states or into Canada. And the reason the difference between Act 9 and Act 16 exists is because the FERC does not have any regulatory authority over the siting of liquid pipelines. So very similar with regards to the commission grants eminent domain, and then ultimately, if there was condemnation proceedings, those would take place in the local court. The Act also defines what specifically a pipeline is. It would be a pipeline that is used or is to be used to transport crude oil, petroleum, or carbon dioxide. The Act requires that the construction will minimize physical impact and economic damage. And again, similar to Act 9, there is authority for the commission to issue penalties if a pipeline company does not meet the intent of the law or a commission order. So now I'll switch and talk a little bit about the process. So an ex parte case would be a case where only the pipeline company and the staff, our staff here, would be involved in that case. To qualify for a ex parte case, there can't be any increase in rates on the natural gas pipelines. There does not need to be eminent domain to secure right of way. So the pipeline company has to have already secured all the right of way that it needs to construct that pipeline. The ex parte case saves both staff resources and pipeline company expenses because the staff will work directly with the applicant to review their application and then ultimately make a recommendation to the commission. So petitions for intervention in a case has to meet a two-pronged test. The intervener must show that it has or will suffer an injury in fact, and the intervener has to show that it has affected interests that fall in the zone of interest to be protected or regulated by the statute or constitutional guarantee in question. So to be an intervener in an application, that those two things would have to be met. So we see a lot of applications where another pipeline operator that may want to serve the same customers or may want to transport the same product would be an intervener in that case. We'll see cases where there will be landowners who will be interveners in those cases because they have property that's going to be impacted by that pipeline construction and pipeline lie on their property. A claim for future injury is insufficient to fulfill the injury in fact requirement, as an injury must be real, immediate, and not conjectural. So you have to be able to show that there is injury that you will be realizing. Mere interest in the proceeding and outcome is not sufficient to support intervention. So just because you want to be a party to the case does not necessarily mean that you will be a party to the case. Any interested parties may file a petition to intervene in the case within the time frame designated in the notice of the hearing, which by rule is at least 7 days before the pre-hearing. So the staff will schedule a pre-hearing with the ALJs, and all the property owners would be noticed of that pre-hearing, and then they may file a petition to intervene, just like the staff or any other pipeline files a petition to intervene. So the other type of case, other than a ex parte case, is a contested case, and this is a case that would go to hearing in front of an ALJ and then ultimately to the commission for a decision. And typically a contested case would require new right-of-way acquisition. There'd be a proposed increase to rates. It could also involve highly developed or environmentally sensitive areas. So areas where there's a lot of structures or areas that involve wetlands, those types of things would be issues where there would be a contested case. Publication of the notice of hearing is required in local newspapers. Typically, there would be notice to the local officials, and like I mentioned before, there'd be notice to all the right-of-way property owners. There'd be a pre-hearing conference, and the staff shows up at those pre-hearing conferences, and that's where we are allowed to intervene in the case, and any other party that thinks that they would have intervening status would have to show up at the pre-hearing conference also. We go through a process of filing testimony in that case, so staff will file testimony and exhibits in the case. We go back and forth with response to audit and discovery requests. So we may make requests of the pipeline company. Others that are interveners may make requests to the pipeline companies, and there can be some back and forth. Sometimes we'll get requests of other interveners to respond to discovery requests. And then there'll be an opportunity for cross-examination of any witnesses that are part of that case, and that'll all be done in front of an administrative law judge. The administrative law judge will issue a proposal for decision after that evidentiary process is over, and then the interveners and staff will have one last opportunity after that to reply to that proposal for decision, and then ultimately all that rolls up to the commission, and the commission issues an order in that specific case. As far as what the staff would do when there is an application in front of the commission, we'll review the application, the testimony and exhibits that the pipeline operator has attached to their application. After we review all that, we'll request audit and discovery responses. So those would be questions that we ask based on everything that we've reviewed. Sometimes we'll ask additional questions on things that we may want to see that weren't part of their filing. So the review will focus specifically on the route, whether the project is necessary or not. We'll ask questions about the safety of the pipeline, how it's going to be constructed, designed, and operation of the pipeline. And then we'll also ask questions about the environmental impact. The staff will put together testimony that will include sometimes additional safety requirements, additional construction requirements. Sometimes the staff will look at the route and propose alternate routes if we think that there's a route that would be less impactful to either property owners or the environment. And then ultimately, those or our testimony will include recommendations to the commission. For public participation in this process, any interested party to the case may attend and participate in the pre-hearing conference. Anyone that's wishing to appear at a hearing to make a statement of position without becoming a party to the case may participate after disclosing their identity and interest in the case. So the ALJ will allow participation and allow a public comment to be made. And you don't necessarily have to be intervening to make a public comment. Anyone can make a public comment. So as far as the effective public participation, it'll depend on really how relevant the comments are to the application. So it's important to keep your comments relevant to the application, and that really makes a difference in how that comment is considered. There are two primary questions that are looked at and to evaluate. Is there a public need for the proposed pipeline? Is this pipeline going to serve the public need by transporting a product that the public needs? So that's specifically one of the things that specifically the commenter should comment on, and one of the reasons that other pipeline companies often intervene in these cases. Sometimes there's alternative routes proposed by other pipeline companies or alternative pipelines that are proposed for moving that product. So that's a critical piece of it. What is the need of that specific project? And then, is the proposed pipeline designed and routed in a reasonable manner? So that's something that the pipeline company includes in their application. And as I mentioned, the staff will review that and determine if the staff agrees with or can propose, something different. And similar with any other person that wants to have a comment in the case, and they need to be focused on that specific or those two specific issues. So that's all I had for comments.
Thank you, Dave. So we will switch over now to Joe.
Hi, Joe's here.
Great.
Let me know if you got a visual on the presentation.
Yep, we do.
Okay. All right, then I'll just start here. I'm Joseph Haas. Call me Joe, please. I'm District Supervisor with the Gaylord District Office of the Environment, Great Lakes, and Energy, EGLE, formerly DEQ. I'm with Water Resources Division, and presentation today, pipeline permitting. I'm trying to make sure I get through all of these. I want to make sure we leave enough time for questions. So here's a brief outline. So we're going to cover regulations, public hearings, public comments, our permit review process, and decision making. In 1994, Michigan's legislature grouped the state's natural resource laws under a single act, and this is known as the Natural Resources and Environmental Protection Act. 1994, Public Act 451, you'll hear it referenced as. EGLE Water Resource Division administers these following laws and associated rules that generally will apply to pipeline permitting, and those being Part 301, inland lakes and streams protection, where any work proposed below the ordinary high water mark of an inland lake or stream would require a permit. And when we're talking about work in streams, you know, we oftentimes will bring in Part 31, which is the floodplain regulation. So that's where you'd have upstream drainage of an area greater than 2 square miles. Then the floodplain review is going to engage. And floodplains themselves are regulated at 100-year flood elevation on the landscape, and that's a 1% flood chance of occurring at any year. So sounds small, but it's not really, and especially in today's climate, we're seeing a lot more 100-year, 500-year, 1,000-year floods. You'll hear them on the news. Part 303 is the wetlands protection statute, and we're looking at defining wetlands as far as areas where there's high water table or hydrology, wetland plants, and hydric soils. Where you have these things combined, you will have a wetland, and generally wetlands in Michigan are protected by the state of Michigan. We have 404 assumption from the EPA and the Corps of Engineers for the inland portion of the state, and also dual jurisdiction, and I'll touch on this again later, with the Army Corps of Engineers on navigable waters and Great Lakes and their connecting channels, larger rivers. And then Part 325, the Great Lakes Submerged Lands Act, is on a lot of people's minds these days with the high water we're experiencing in the Great Lakes. So Lakes Michigan and Huron are regulated at an elevation of 580.5 feet, and that's International Great Lakes Datum of 1985, and that's the statutory ordinary high water mark of Lake Michigan and Huron, effectively one big lake. All the Great Lakes have a different ordinary high water mark set in statute. I think Superior's is 602.6. The federal ordinary high water mark is a foot higher. So for Lake Michigan and Huron, it would be 581.5, just to properly confuse things. Also, it's worth noting that the state of Michigan, and Eagle in particular, is exercising Part 325 authority right now when water levels are above the ordinary high water mark in waters of the Great Lakes, no matter what the water level. So, you know, even though they're above that statutory ordinary high water mark, we are regulating the surface area of the water. And we have an assistant AG's informal opinion on interpretation of Part 325 that we're confident affords us this. Also, the issue of conveyances comes into play with Part 325 on the Great Lakes bottomlands. So we have the authority to convey Great Lakes bottomlands for private use. And examples of that type of conveyance are leases for commercial marinas, agreements for some coal and stone product docks at various ports. And there's some deeds that are afforded for filled subdivision lots on Lake St. Clair that I'm aware of. So where you look at large marinas that have a footprint on bottomlands, they typically would have a conveyance that's authorized through the Eagle Great Lakes section. There's also DNR easements, and this comes into play with pipelines in the Great Lakes. So DNR would oversee Great Lakes bottomlands. I often refer to these when people are asking about them as similar to a state park. So the bottomlands of the Great Lakes are owned by the state of Michigan. And DNR would oversee Great Lakes bottomlands authorization for utility easements. So it's, again, just to properly confuse things, it's not solely Eagle that regulates bottomlands, but DNR handles the utility easements. And some examples that people might be familiar with are Trans-Canada in the Straits, Enbridge Line 5 in the Straits, those pipelines, and then ATC and AT&T have cables through the Straits as well. So they all have easements through the DNR. And just a little bit more about wetlands. So Part 303 is the wetland statute, and so that's regulated. The regulated activities are placing fill, dredging, or removing material, operate or maintain any use or development, draining surface water from a wetland. So projects that involve a maintained utility easement are a use, and so that really applies oftentimes, commonly with pipelines. There's a permanent change in the character of the wetland. That's a maintained use, and a permit would be required for that, and mitigation as well once it's over 1/3 of an acre. So changing the landscape from a forested wetland to a scrub wetland is pretty typical for pipeline installations, where they need to, and are, I think, statutorily they're required to maintain. I think the regulations changed that required them to maintain the landscape above their pipelines so they can have a view shed and observe. They fly them pretty regularly, once every 2 weeks or so, depending on what they are, in order to make sure they can observe any leaks or any infringements on the easement. Anybody looks like they're ready to excavate in the easement and they weren't aware of it, those sort of things. So it's just so they can monitor their easements and their pipelines. And again, Michigan has authorization from the federal government to administer Section 4 of the Federal Clean Water Act. Michigan and New Jersey are the only 2 states with this authority, and the state 404 programs have to be consistent with requirements of the Federal Clean Water Act. Also, the Corps of Engineers retains the federal jurisdiction over traditionally navigable waters. This would typically include the Great Lakes, connecting channels and other waters connected to the Great Lakes where they have a navigational concern. So this is, again, the Section 10 waters. And this is a real busy slide that the type is a little bit blurry for me, but you get the point that there's a lot of regulations that the Eagle oversees and implements. So we have authority under Part 301 in the lakes, Part 303 wetlands protection, Part 315 dam safety, aquatic nuisance, subdivision control act. Part 91 is the soil erosion sedimentation control act that's implemented by local units of government or counties. We oversee that and make sure they're consistent. Anyhow, you get the idea. There's a lot of regulations that we have authority over. There are utility exemptions too. Part 301 utility line has exemption for the use of when they're using directional drilling or boring to conduct crossings. They have to generally maintain a minimum of 10 feet from the top of the conduit and the bottom of the lake or stream. There's some other requirements as well, but this is sort of the key one when it comes to pipeline and utility lines. And also exemptions from Part 303 wetlands protection, where you would not have to get an Eagle permit if the utility line is 6 inches or less. And again, they're using directional drilling, boring, or they're knifing it in with, again, overseeing certain other standards. But the key here for the exemption is the top of the utility line is at least 4 feet below the soil surface of the wetland. So just to move into the public hearing and public comment section, I wanted to make sure I fit this in so we don't get pinched for time. I know that's the focus of today's webinar. And the overall concept of a public hearing is often confused by attendees that aren't familiar with the process. It's an opportunity to formally comment on the public record, but it's not an opportunity to vote on a proposal. And people get frustrated with that when they see their numbers opposing a particular project or a particular proposal. And what we really are looking for is substantive comments. So, this is a formal administrative meeting where comments are received and recorded. It's not a dialogue or a question and answer with the agency. The agency is an agency seeking firsthand knowledge about local conditions, in order for those that might have knowledge to provide that sort of historical point of reference and knowledge of resources in the community. So stuff to keep in mind when you're compiling comments for submittal, either written submittal or verbal or oral submittal at a public hearing. Stick to the facts, particularly the facts of the site. The regulatory legal basis for laws and rules, as far as your comments go. Make sure that you're sticking to those facts. Express your comments briefly and factually, especially if you're talking about commenting at a public hearing. We typically would allow between 2 to 5 minutes, depending on the attendance and the size of a hearing and the time limit that we have. We usually would count heads or count the cards for people that want to comment at a public hearing, and just split up the time in an equitable manner. We want to make sure everybody that wants to speak at a public hearing has an opportunity to speak. So it's a good idea to practice your statement if you're going to submit a verbal statement at a public hearing. Make sure it doesn't go too long. If you've got a statement that's going 10 minutes, it's not likely we're going to be able to hear it all. And it's important to keep in mind there's no real limit for written comments. If you want to write something out and submit that is fine. That is encouraged, in fact. And we have a way you could submit them electronically through our MyWaters permit database. And I would highly recommend you seek that out. That would be listed in any public notice. There'd be a link provided, and you could submit any written comments you like in that fashion, and that would again encourage that. Something to keep in mind too is if there's enough interest in a public project, in a public notice project, we could hold an information session. Typically, we would do something like that immediately prior to a public hearing, so people don't have to travel twice to attend. It's going to again be driven by the time that we have allotted for that the public hearing would take, depending on attendance and expected attendance. And these things can be hard to predict, but I know we've had public hearings that have gone practically a whole day, where we've split, broke for lunch, came back, reconvened, split again, and broke for dinner and came back after dinner. So these things can be quite long and oftentimes a lot of work, a bit of a marathon at some of these. But again, we want to make sure we give everybody an opportunity to comment. So permit review. We have a MyWaters online database. That's for applications for permit, the joint permit applications, as well as compliance. If you want to file a complaint, you can do that in MyWaters. We require all of our joint permit applications. All applications now are required to be submitted electronically online. It's the real exception that we will accept a paper application, because then we have to enter it. It takes a lot of time and effort. It's again the exception. It's all online and digital. So the JPA, the joint permit application, a public notice is required for all JPAs that involve wetlands, lakes and streams, or bottomlands that don't meet the minor project and general permit category. So when submitting a JPA that's required to be public notice, we're going to ask that the applicant submit the names, mailing addresses, do the work for us for all adjacent property owners impacted by the project. So that's a requirement. The notice would typically include a summary of the project, a copy of the permit app, location information, drawings of the proposed activities. And we would just distribute that public notice. Typically, you want to be signed up for our electronic distribution, our calendar online. We used to publish them in a newspaper. We still will do that, but newspapers regrettably have been dying, and that's not a very effective way to communicate public notice information. And so we really have to ask that the public be an advocate for themselves and their interests and seek these out. You can ask us to mail a hard copy to you. We're willing to do that. If you request a paper copy, you can call the district office and we can make that happen. Any public notice is also going to be available for viewing at the district office that's assigned to that file. You could frankly probably go to any district office and get a copy of a public notice if you needed to. Again, because they're all online in the MyWaters database, and the district office should be able to call that information up. So the file review for Eagle and Water Resource Division, the review starts with determination of the completeness of the application. Typically, we send out what's called a correction request, which is a request for additional information to clarify information that was either not provided or it seems to be unclear. We send a correction request out on probably 90% of the applications we get. And that's just a testament to the thoroughness of the field staff. We have 30 days to determine if a file is complete or request additional information. After that 30 days from the date of submittal, the file is automatically considered complete. Regrettably, it might sound like a long time, but we have regrettably quite a number of applications, and oftentimes staff are stressed to make this initial determination. We don't let the big ones slip, I can tell you that. If we know we've got a wetland application, because they are automatically authorized at that point after 30 days if we haven't requested any additional information. So we make sure we get those correction requests out on files that look like there's a significant amount of impacts proposed, or it's something that's of great interest to the public. We would determine jurisdiction in our file review. A permit would be, a permit is required for what? Part 301, Part 303 as well. What statutes apply is the review that goes on there. Staff would begin the technical review and conduct a site inspection once the application is determined to be complete. During the field inspection, we can find additional information that would lead us to the fact that the application doesn't fully represent what might be proposed. And we would then contact the applicant and ask for additional information to clarify. Decision extension requests are available, but the applicant needs to make that request. Oftentimes we, as field staff, will go to the applicant and say, look, we need you to make a request for an extension. We can't foresee this getting sorted out because, X, Y, or Z, and some of it's under the applicant's control. And so we would oftentimes encourage an applicant to ask for extension. Generally, we're taking about 30 to 90 days from the time we receive a complete application until a decision is made on a permit. We do have emergency permitting capabilities with high water. We've done a lot of emergency permitting with severe erosion on the Great Lakes and threats to structures. That's of primary importance. Secondarily, we would respond to just severe erosion with no structural damage. But really, if somebody's house is threatened, that's a real health emergency, and we'll move on that as fast as we can. So other factors that would be included in our review are, and might complicate and extend the time, are the size and complexity of a project, the number of corrections we send out, additional information that's required for an application to be administratively complete. If we require a public notice and a public hearing, that's going to extend the time towards the greater end of it. We also need to make sure we're collecting the correct application fee, and oftentimes that's not submitted correctly. That's probably one of the more common mistakes from an applicant's side. And processing times can be longer with that public notice again, or if a public hearing is held. So if a federal permit is required, where activities proposed in Section 10 waters, the application is sent to the Army Corps of Engineers Detroit District Office in most of Michigan. There's some portions of Southwest Michigan, I think, are regulated out of the Louisville District with a field office in Indiana. But once we determine that an application is administratively complete, we share it with the Army Corps of Engineers. So an applicant only needs to submit a single application, and that's the reason it's called the joint permit application, the joint being between the state and the feds. And so permit categories that we have are GP, which stands for general permit. and that's a $50 application fee. An MP is a minor permit, and that's a $100 application fee, and an individual permit is a $500 at a minimum $500 application fee. And that's listing them in this sort of least impacting to the more impacting permits. GPs and MPs have already been public noticed. I think the GPs and MPs we have out right now were public noticed and signed off on by our division director about this time last year, 2018. So you have an opportunity as a concerned citizen to comment on the GPs and MPs. You just got to watch for them when they're noticed. The individual permits are, again, public notice every time. But the idea of MPs and GPs is to reduce the time and cost of the permit process for applicants, considering that these are generally minor activities and we want to reduce their cost, our cost of administering the program while we're still protecting resources. So we in fact work to get applicants to meet the least impacting category possible. So even to the point where we can request such a modification where a permit might not be needed, right? That's an ideal situation where we sort of work ourselves out of a job, if you will. We get an applicant to modify their application or their project so it's not impacting any aquatic resources and they don't need a permit. That's, again, the best case scenario. Our overarching permitting concept is avoid, minimize, and mitigate. So if we can get somebody to completely avoid impacts, that's great, right? And if they can't do that, then we need them to minimize to the greatest extent possible. And if you can't minimize and you're looking at 1/3 of an acre or larger, you're required to mitigate. We can require mitigation for less than 1/3 of an acre of wetland impacts, but I'm afraid that's probably less common than a lot of people would care for it to be. So in our application review, we're going to determine our adverse impacts, and those would be impacts to threatened or endangered species, adverse impacts to fish and wildlife, recreation, aesthetics, navigation, archaeological sites. We're asking ourselves that question, would the proposal adversely affect water quality? So applications for a permit have to comply with Part 401. This is Federal Clean Water Act 401 water quality certification. Before a federal permit is issued, the state has to provide that certification. And that's true, I think, in all states, not just Michigan, but it's sort of baked into our process, if you will, where you don't explicitly see a water quality certification printed out or posted. It's part of our permit. So that's something a lot of people aren't familiar with. The other issues, adverse impacts to natural rivers for projects under 301 or Part 325, so under lakes and streams protection or Great Lakes protection, projects that might adversely impact riparian rights. That's particularly of interest to 301 because commonly riparian property along in the lakes and streams is typically owned by the adjacent property owner. There's exceptions to all this. Riparian law gets really thorny, but that's the typical ownership pattern. Is the riparian owner owns the bottomlands. They don't own the water, but they own the bottomlands. They have a right to the water, to use the water, but they don't necessarily own all that's over the bottomlands. So if work was proposed on state-owned bottomlands, then we would certainly want to be involved. We would be engaging with the DNR, and we would also be engaged as a state agency. And we're going to look at adverse impacts and consider, is a proposed project consistent with similar structures or permits that have already been issued in the area? And wetlands, again, adverse impacts for wetlands. Would a project proposal be in the public interest? Would it adversely affect aquatic organisms? Is there a loss of values? We also are interested in we're required to review an alternatives analysis. So an applicant has to define a project purpose and we will investigate feasible and prudent alternatives and review that with their application. So water and wetland dependency is key to investigating the feasible and prudent alternatives. So for an example, for a wetland dependent activity would be peat mining. So that's wetland dependent. You can really only mine sphagnum peat in a wetland. Once the water is drained, it's no longer a wetland. That sphagnum decomposes really quickly. A marina would be an example of something that's water dependent, right? You'd need to be on a lake or a large river or Great Lakes. Wetland or residential development is not wetland or water dependent, right? You can build a residence in an upland, and I would venture to say pipelines are generally going to be considered in that same sort of category, not as residence, but as not wetland dependent or water dependent. Although the permit review is going to look at, compliance with other regulations, the cost of pursuing a project. These linear projects are difficult to navigate through the landscape, and so we're going to, there's going to be other provisions that we're going to be considering when we're looking at permitting a pipeline. So an alternative can be considered feasible and prudent if both of these provisions apply. So the alternative is available and is possible to be done after taking consideration cost, existing technology, and logistics. So that sort of pulls into the previous thought that I just discussed concerning pipelines. So consider cost and logistics of a pipeline snaking around every wetland or stream crossing. It's going to be difficult. It's going to, especially in a state like Michigan where we have so much water resources, they're going to end up with stream crossings, without a doubt. The other provision would have a less adverse impact on aquatic resources. So an alternative could include using a different location than the proposed location, a different configuration, a different size, a different method to accomplish the same purpose. So an applicant needs to demonstrate these things to us. They have to demonstrate that there's no feasible and prudent alternatives that have less impact on the aquatic resources, and that's the burden that they bear. They have to define the project purpose, because that defines the scope of the alternatives analysis. So the only alternatives that will achieve the project purpose can be considered by the applicant and assessed by the state, by Water Resources Division. So part of our review is determining if the activity will result in unacceptable impact to aquatic resources. So is it otherwise lawful and in compliance with other regulations, sort of other applicable state or federal laws? Some projects also do require local approvals, such as zoning, land use plans, or watershed plans. We would typically issue a permit without those local approvals. We won't wait for the locals necessarily. We can issue it contingent upon compliance with other regulations. So our permit decision then comes down to what we would say is three words similar to avoid, minimize, and mitigate. The permit decision is issue permit, modify the application, or deny the application. Once we've gone through this permit decision, we would issue a final staff recommendation. Under Part 301, we can't issue a permit unless we determine that the adverse effects are minimal and will be mitigated to the extent possible, that resource affected is not rare, and that the public interest in the proposed development is greater than the public interest in avoidable degradation, and that no feasible and prudent alternative is available. So Part 303, unless the department determines that issuing a permit is in the public interest, the permit is necessary to realize benefits from the activity, and the activity is otherwise lawful. We show that there's not an unacceptable disruption in the aquatic resources. And the applicant has to demonstrate that the proposed activity is dependent upon being in a wetland, or a feasible and prudent alternative does not exist. So that's oftentimes a difficult task, because again, there's not many activities that are wetland dependent. Permit would not be issued under Part 325 unless the department has determined that the adverse effects to the environment, public trust, and riparian interests of adjacent owners are minimal and will be mitigated to the extent possible. It's tough to mitigate Great Lakes, and that there's no feasible and prudent alternative. So you see these sort of thoughts that keep repeating through the feasible and prudent alternative idea, and our concern for requirements to public health, safety, welfare. Additionally, we would write a narrative up to fully outline the department's findings. This is often called the basis for decision. These are really with the large files. It's not done on all files. Only with real complicated, large impacting projects. So if we come up with a recommendation for denial, we'll have, we need to have a clear identification of the statutory basis of that, and that goes as well for permitting. We are a permitting agency, and honestly, we issue more permits than we deny, for sure. And in fact, most applications will either be worked towards a permit or a modification that's permitted. Again, 90% of applications are modified so we can permit them, and they meet the statutory criteria for permitting. I think we have a reputation for being a little harder to deal with than oftentimes we are. We really try to have a customer focus and be consistent in our implementation of the statutes we're tasked with. I think that's all I have. I'd just like to thank you guys for your interest, for working to be informed and involved. It's much appreciated. And so that's me. Sorry, Jen. If you need to call, you have questions, feel free to reach out to me. I'll let you take it off, Jen.
Thank you, Joe. I appreciate that. So we do have a few questions that have come in that we will go through in the last few minutes that we have. The first one for Dave is a clarifying question regarding condemnation, and if it applies only to land occupied by Michigan highways.
No, it does not.
Okay. So it can occur to other lands in Michigan, correct?
Correct. Okay. And again, all that would be handled in the local courts.
Okay, thank you.
The commission, the commission just, grants the eminent domain for them to seek condemnation.
All right. Joe, how does a person get on the distribution lists for the JPAs, the joint public joint public applications?
Yeah, I think you can go to the Eagle website and probably just type that in, or Google EGLE public participation. It particularly sounds like you may be interested in water resource types of applications. I think you can get on the calendar. It's a sort of a checkbox. You can toggle whatever counties you're interested in seeing. You can select the whole state if you want. So if you send me an email or call me, I could send you a link. Jen, maybe we could include a link in the materials following up on this.
Absolutely, that would be great. This question is for both of you, actually. Does the state ever deny a permit for a pipeline, and if so, how many? Dave, you want to go first?
Sure, I can go first. The one that comes to mind is the Wolverine pipeline through Lansing. And this goes back several years ago, but there was an application before the commission to reroute the pipeline pipeline as it goes through some very populated areas. They wanted to use some highway right away and go around the populated areas and get out of the Lansing proper, and ultimately that pipeline was never constructed. So to answer the question, I would say yes, that definitely is a possibility. I do want to follow up with one thing also too, related to Joe and I. I know we talked separately, but when we have an application before the commission, we work with Joe. We meet with all the state and all the federal agencies to talk about the pipeline route, to talk about the permitting that each of the agencies is going to do, and to kind of open up the lines of communication and interact with the other agencies. So there is some work that's going on between the agencies with regards to what both and all the agencies do. And that was a recommendation from the 2015 Michigan Petroleum Task Force report, and we took that very seriously in all applications that are here. We're taking opportunity to consult with others.
Thanks, Dave. That's a good point, Dave. Appreciate that. So in my permitting history, personally, I have not seen a pipeline been denied. All of them have really been small projects, small diameter pipes. So they've generally fit into one of our GPs or MP categories, been commonly exempt because they meet that exemption. But I think in the future, if you're looking at some pipelines that are likely to need to be replaced, we're probably going to be looking at a very critical review and mitigation and those sort of requirements. But I don't have a crystal ball to predict the future, but I can tell you in the past, I don't have experience or knowledge that former DEQ, now Eagle, has denied permit applications for pipelines. But then again, I have not seen a large number of permit applications, and particularly not for large pipelines.
Thank you. A couple more questions. Dave, how would a commenter ever be able to know the injury will happen when it's a proposed pipeline?
I think the key there is someone who is going to be impacted. So if you look at a pipeline route and it goes through your property, including DNR property, I mean, they can be an intervener in a case too. So if that pipeline construction is going to impact you, then you know that there is the potential for there to be damage, and that's the key. So, if you're 20 miles away from the pipeline, there's no impact that you could see from that pipeline construction.
Okay, thank you. And then with regards to Enbridge Line 5, since it's owned by and the majority of product goes to Canada, what is the public good, and how would you consider that during an application process?
Can you re-ask that?
So the question is looking at the public good and the public necessity with regards to Enbridge Line 5, since the majority of the product goes to Canada. How would a situation like that be reviewed? Necessity. So
we would look at where all the product is going. So in a situation where there's propane that's coming to Michigan, where there's crude that's going to the Marathon plant in Detroit, and crude going to the Toledo plant, and a lot of that refined product is coming back to Michigan. So we would look at, what products are being used in Michigan.
All right, and with that, we are out of time. So I would like to once again thank you, Dave and Joe, and the Pipeline and Hazardous Materials Safety Administration for funding the webinar, as well as all of you who are able to take time out of your day to attend. And again, we have resources coming out this month, so stay tuned. Thank you all.
Thank you.